And you may inquire of the witness.
Good morning. Can you state Can you state your name for the record and spell both your first and your last name, please?
Yes, sir. Adolfo Cavelli, Adolfo. Last name Cavelli, C-O-V as in Victor, E-L-L-I.
Okay. And I believe you testified a few days ago. Were you a senior official at the Waste Pro location here in Fort Pierce in August of 2023? Or I'm sorry, August of 2018.
Yes, sir.
Okay. And were you familiar with the trash routes of the drivers in August of 2023?
Yes, sir.
Okay. Were you specifically familiar with the trash route of the defendant, Jose Soto-Escalera?
Yes, sir.
Okay. Did he have a trash route in northern Fort Pierce?
Yes, sir.
Okay. Can you tell the jury what his trash route was?
Yeah. I can't give you the exact every road and all that, but it was in North Fort Pierce, in the Andrio Road area, Johnson Road, Rousseau Road, around the Spanish Lakes area, in northern Fort Pierce, St. Lucie County.
Okay. And can you walk the jury through was there a system in place where each of the employees of the Waste Pro, if they were on a garbage truck, what was their knowledge of the camera and recording system?
Yes, sir. So I was there when we had the cameras installed, and every employee that was in the vehicles had to acknowledge that they were being recorded both by audio and visual recordings.
Okay. So did every employee who was assigned to one of those garbage trucks have specific knowledge that they were recorded?
Yes.
And that they were videotaped?
Yes.
Okay. And how well did you know the defendant, Jose Soto-Escalera?
He was an acquaintance and an employee, like most of the employees. I was very close with them to get to know their families and ask about them, and Jose was one of those people too.
How long do you think you knew him?
I would say backing up from 2018, a few years. I believe Jose worked for us and then left and came back, but regardless, I've known Jose since his employment at Waste Pro.
Did you have many conversations with him?
Yes.
Did you know him it sounds like you knew him in the context of work, is that correct?
Yes.
Did you also know him socially?
Yes. Yes.
Okay. Do you know him well enough to visualize him, identify him?
Yes. Okay.
We're looking here at a freeze frame of one of the videos from exhibit number 169. If you need to, step down, but do you see Jose Soto-Escalera on the smart TV?
Yes.
Okay. Can you identify him? Which one is he?
The gentleman with the glasses and the steering wheel in front of him, to the right of us, looking to the right.
Okay. And who is the other individual in the vehicle?
I'd like to come up with that.
Sure. Who is that?
The helper of the route, Eric Alvarado.
Okay. And did you speak to Jose Soto-Escalera enough to recognize his voice?
Yes.
Okay. And based on that familiarity, if I were to play you a clip from an audio of exhibit number 169, would you be able to recognize his voice?
If I hear it, yes.
Okay. Okay, so for the record, we're going to go to page 10, line 167 of the transcript. It will be at 5 hours, 59 minutes, and 48 seconds. right there. Did you hear two voices in that clip?
Yes,
Was one softer and one more audible?
yes,
Okay. And are you familiar also with Eric Alvarado's voice?
yes.
How long had you known Eric Alvarado for?
Since his time of employment, I don't recall exactly how long. It was a shorter time period than Jose Soto.
Had you had multiple conversations with Eric Alvarado?
Yeah, I'd greet the team every single morning, all the employees, yes.
Okay. And can you tell the jury the identity of the individual whose voice was less audible in that clip?
The one that had a lower voice,
Yeah.
Eric Alvarado.
Okay. And can you tell the jury the identity of the individual who had a more clear and more audible voice?
Yes, that would be Jose Soto-Escalera Soto.
Okay, thank you. I'm now going to show you yeah, now we're going to publish States 170, okay? Okay, I'm going to show you a video from August 21st of 2018. Okay, yeah. Yes, okay. Are you, can you take a look at those individuals in that one that's working?
Yes,
Okay. Do you recognize who the driver is?
yes.
What's his name?
Jose Soto-Escalera.
And do you recognize who the passenger is?
Yes,
What's his name?
Eric Alvarado.
Okay, thank you. Yeah, we'll go to August 23rd of 2018. Video. Yep, and here we are looking at a video from August 23rd of 2018. Who is the driver
Jose Soto-Escalera.
and who is the passenger?
Eric Alvarado.
And here we are looking at August 25th of 2018. Who is the passenger?
With the sunshine, do you mind if I walk up, please?
Sure.
Thank you.
What's the identity of the passenger?
The passenger is Eric Alvarado.
And the driver.
Jose Soto-Escalera.
We'll go to the 27th. Okay, same question on the video from August the 27th of 2018. Who is the driver
Jose Soto-Escalera,
and who is the passenger?
Eric Alvarado.
Okay. If we could return, we're going to do one more. Sir, thank you very much. That's all the way left.
Thank you.
Any questions from the defense?
No, Your Honor.
May Mr. Cavelli be released from his subpoena at this time?
Yes, sir. You may.
Thank you, Mr. Cavelli. You're released from your subpoena. You're free to stay or leave as you wish.
Thank you very much, sir.
Thank you. And the state's next witness or item of evidence.
Your Honor, at this time, the people said for arrest.
Ladies and gentlemen of the jury, at this time, the state has rested its case. Let me ask you to step back into the jury room for a moment. Please do not discuss the case and leave your notes on your chairs, and we'll be with you momentarily. All right, the jury has exited the courtroom at this time. The state has rested its case. Any motions from the defense?
No motions from the defense.
Okay, and from the defense, no witnesses other than whether the defendant is going to testify. Do you need time to
If you
confer?
have a moment, Judge.
Sure,
It won't take
confer
long.
with the defendant to make a decision whether he wishes to become a witness. I'll inquire of him in that regard, and then we'll go from there. But we'll go off the record, giving the attorneys a chance to speak with the defendant to make that very important decision. Go off the record. Witness at this time. Mr. Soto-Escalera, you can be seated, but if you raise your right hand, the clerk will swear you just for a brief inquiry from me on that particular point.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Mr. Soto-Escalera, the decision whether to become a witness in the case, unlike most decisions in trial, is personal to you, meaning you receive the advice of counsel, but you make the decision up and above their advice. If there's a disagreement as to whether you should testify, you get to make that call, even if you disagree with your attorney. You have received their counsel. Are you first of all, do you understand the decision is personal to you?
Yes, sir.
Are you deciding to testify or not?
Not, sir.
Not. Are you doing that of your own free will?
Yes, sir.
I will find that you're making the decision not to become a witness freely, knowingly, and voluntarily, and will proceed in that fashion. And therefore, let's discuss the plan. My suggestion is to release the jury till when they come in, have the defense rest, release them till 1 o'clock. We'll do a quick charge conference and give you the remainder of the 2 hours to polish your closing arguments and proceed at 1 o'clock. Is that a good plan?
I think the parties might have agreed a different plan, Judge.
Okay. Well, I'm open. I'm open. I'm just, okay. I know we talked about finishing tomorrow too, which is possible. Is that what you had your eyes on?
Yes, sir, if that would be okay with the court. Yeah, Friday works better, if that's okay. We've had a long 3 weeks.
I'm open to that. Of course, the advantage if you do it this afternoon, I realize, I've done your jobs as well. So I realize, what goes into a closing argument. The advantage is, if there is a conviction, you get tomorrow off to prepare. There's that too. But either way, is that what you both agreed on?
Yes, sir.
Okay, that's fine with me. All right, so then I would bring in the jury, have the defense rest, and then tell them they're excused for the rest of the day. We'll do closing arguments tomorrow morning.
I do have a suggestion, Judge.
Sure.
And, you can deny
Close tomorrow?
it. What?
Rest tomorrow for you?
No. No, I don't mind resting now. I was just wondering if we could do the charge conference now and charge the jury today, and that way when we come back tomorrow, we could just go straight into closings and then they deliberate.
Fine with me.
You want me to read the instructions to them before your closing arguments?
Yes, sir.
State agree?
That read all the jury instructions before?
Correct, that's the
Yes.
request.
You mean today or tomorrow?
Today.
Today.
That way we make good use of the time.
So then what
Yeah.
we would do closing, and then you would remind them and say, I read you the law yesterday?
Yeah, I've never done that, but it's a standard practice with other judges. There's nothing wrong with it.
And they're gonna get a copy of it anyways.
Exactly.
Yeah, fine with me.
I just think that'll give them something to ruminate
Saves us
over
time.
tonight.
I have no problem. It's time efficient for me.
Right.
And I always wonder why there's not more requests to do that, because they'll know what the law is before you make your arguments as opposed to the other way around.
Exactly.
Okay. And I'll tell them the attorneys have agreed with this procedure. I'm going to instruct you on the law, and then they're going to make their arguments tomorrow. Don't form any definite or fixed opinion. At this time, you haven't heard their arguments.
Correct.
Are you going to tell them in the instructions about their ability to review the testimony again? I think the only issue was the way it was said could be interpreted that they have to listen to the whole trial, and that that rule only applies to individual witnesses.
Well, let's do the charge conference now.
And
Yes,
get
sir.
to it
Do you have my latest?
Yes, sir.
You have my latest email in that regard. I just took out, obviously, the defendant has become a witness. What I have remaining for your consideration, from my perspective, before we go back to the beginning, under weighing the evidence, can I take out, has the witness been convicted of a felony?
Yes, sir.
Because there's no such thing in this case. Okay.
Correct.
And how about, my default position would be to leave it in, but any pressure or threat been used against the witness that affected the truth of the witness's testimony? We could have had that in this case, but I don't think is there any of that? Anybody want that?
No, sir.
State?
I couldn't quite hear, I'm sorry.
Has any pressure or threat been used against the witness that affected the truth of the witness's testimony?
Not requested.
Both sides agree. I'm going to take that out. So now we have, in that section, 7, with the extras being offered to receive money, which there is, and make an inconsistent statement, which there also is. And, all right, so going to the top, any objections to the way I have it? You may, I don't know if you caught this, because the last version I sent you, I don't think I alerted you to this, but there was one section I added in, unborn child, where it should be. I don't know if you caught that, but it's there now, and it's proper in one of the unborn child instructions. I think it was actually on what should be page 5 for you, lesser included. That last sentence, the lesser included crimes of first-degree murder of an unborn child or second-degree murder of an unborn child and manslaughter of an unborn child. Before it said just second-degree murder or manslaughter, so I just added that in. It's a very slight tweak. You may, if you see that. But so we have introduction, statements of charges, introduction to homicide, justifiable homicide, excusable homicide, first-degree murder as to count 1, count 2, first-degree murder of an unborn child, lesser included crimes, and then second-degree murder, lesser offense as to count 1, manslaughter as to count 1, second-degree murder of an unborn child as to count 2, manslaughter of an unborn child as to count 2, plea of not guilty, reasonable doubt, weighing the evidence, defendant not testifying, defendant's statements, rules for deliberation, cautionary instruction, verdict, single defendant, multiple counts. As to all of that, any objections or suggestions before I get to the part Mr. Cormier mentioned, which is, I'm going to get to that, what I have now. You could see what I have as far as, it's the second to last paragraph. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most, but not all, of the exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine an exhibit in evidence that was not sent back with you into the jury room, please let us know, and we will bring you into the courtroom to do so. that's my standard instruction. I don't touch the issue about rehearing testimony at this time. If they have a note, we do. And what I was alluding to when I spoke to them about that was the default position is to play the entire testimony of those two witnesses, which is the safest, more proper thing to do. I have had it sometimes, and the law does allow, if they specify to us one particular place, you could do that. But in this case, it's going to be extremely difficult. I'm not sure how they would do that unless they were going like section 3 or something like that, as Mr. Richardson was referring to it. You know, if they did that, perhaps there would be an agreement, but otherwise it'd be the default position. And those portions are really not very long anyway, so my default position would be to do that, but it's not addressed in there. So do you want some time to look over what's there and see if you have any objections to it before I actually instruct the jury?
On page 2.
Page
If you go
2.
to Count 2. In element 2, there's just a typo for the name of the defendant. Actually, and also in element 1.
You're saying page 2. I have page 2 is excusable homicide.
So do I.
Oh no, I'm sorry. I'm sorry. Count 2, first degree murder of an unmoved child.
So, yeah, it says
Page 5.
Soto-Escalera.
Oh,
And I
look
think
at
it's
that.
spelled
Okay,
wrong in the
gotcha.
front.
Yeah, it's spelled wrong in number 1 as well.
It is spelled wrong in the word?
Yes, it's an
E-R-A.
E-R-A.
Oh, okay, gotcha.
And I think in the other count you had his middle name.
Let me see, hold on.
And sometimes it has Tanya's middle name and sometimes it doesn't.
Her middle name or his?
His.
And hers, sometimes she's referred to as Tania Wise, sometimes she's referred to as Tanya Esther Wise.
Did anyone have a problem if I just get rid of the middle names and we say Jose Soto-Escalera and Tania Wise? Because middle names, like, why are we?
No
It's like a
objection.
wedding
No objection.
invitation or something, you know.
No objections.
Okay, so I will go ahead and do that. Let me see, hold on. Let me go ahead and do that. As you're reading over the rest of them, just taking my time and without using controlled find, just going through it, so don't make any other.
We don't have any objections or conditions.
They look good, okay.
Yes, sir.
State's still looking over the instructions, right?
Yeah.
Okay.
I have no objection to this.
Okay, let me finalize the issue about names.
Yeah, but,
It should not.
right,
The blank.
right,
Because
right.
it never went into evidence, it's just
Right.
a placeholder.
Yeah, I'm just going to reflect this on that.
Perfect.
Okay.
Of course, and one of the advantages of doing this too is if there are mistakes that are catch in the instructions, orally I'll correct them, and then I'll correct them in writing so that they get a perfect copy. It's actually better in that regard. So as I read along, does anyone want a hard copy of the instructions finalized?
I would.
Okay, do that. What I'll do tomorrow too is, it's my normal practice in reading the instructions to explain the verdict form. I won't do that. I'll read them the verdict part, but I'll explain the verdict form to them after your arguments tomorrow before they go back, because it's normally, that's the purpose of that. You're about to go back and deliberate. Also, I also, submitting case to jury, I should probably read that tomorrow. So I'll just stop at single defendant, multiple counts. Tomorrow, I'll reiterate verdict, single defendant, multiple counts, and submitting case to the jury, explain the verdict form, and then send them back tomorrow. But at least I'll get the full instructions on the law at this time. Here's a copy for each side, hard copy. And let's bring out the jury and I'll instruct them. Do ask those who are here in the audience, you're free to remain, but you must remain during the whole instructions. I don't want people coming in and out of the courtroom while I'm instructing the jury on the law. do doing that tomorrow. Unless you just want to forego your closing arguments altogether. No?
Unless you're gonna defend me on
Right. I think I'd urge you to do your closing argument.